Good evening, this is John Milburn for Laws 12063 Advanced Statutory Interpretation and Drafting. We're into week 3. Just a reminder that we have some terrific resources available for you, referred to in the material, and tonight I particularly want to introduce some material which is available through the legislative or executive branches of both the Commonwealth and the state government that I think you should consider. I'm going to share the screen. You'll find the reference to this material in your study guides, and you should see that now on the screen. So in terms of the Commonwealth Department of Prime Minister and Cabinet, the Cabinet Handbook, 10th edition, and then we have Australian Senate Practice, and I'd particularly like you to look at chapters 12, dealing with legislation, and 15, dealing with delegated legislation and disallowance, and chapter 10 of the House of Representative Practice, and from the Queensland Government, the Queensland Department of Premier and Cabinet Handbook, which is available through the Premier's office. If you haven't found that material in the resources, please look for it. If you're having difficulty finding it, then please ask through UCRU, and I'm sure that we'll be able to assist. And I know that some of you have been accessing this material already, and I'm very pleased to hear that. Just as a sample, some of the material that you can find in the commentary is not only valuable as an aid to understanding, but also it has material that is very useful in terms of reference material. So here we have, for example, a flowchart dealing with the scrutiny of delegated legislation. This comes from ODGA's Australian Senate Practice, and this shows the way in which delegated legislation works its way through a process. So that's the sort of information that you can access, and I do hope that it helps you in terms of dealing with your assessment work. Now, I mentioned delegated legislation, just a few words on that. You'll find that there is material available to you about the making of delegated legislation. I've shown you the flowchart. And the procedures you would have seen for making delegated legislation are remarkably different to the procedures for making legislation per se. Have a look at the material and the way in which it ties in with at a federal level, the Federal Register of Legislation, which provides the authorised source of all Commonwealth Acts, and have a look at sections 15A through to 15E of the Commonwealth Acts Interpretation Act in that regard. Also consider the way in which rule makers undertake appropriate consultation and receive reports. So many of the reports that are available for parliamentarians, both in terms of considering primary legislation or delegated legislation, are generally available to you, and they're a great source of information about the substance of the legislation and also issues to do with procedure. So, for example, one of the procedures relates to disallowance, and you may have read about disallowance. In that regard, have a look at the Legislation Act, have a look at section 42(1), and you'll see that that section says, if a motion, subsection E says, if a notice of motion to elicit, actually I'll just share this on the screen. So I'll just bear with me a moment while I get this ready for you. And I'll share the screen now with some further commentary that I want you to consider. So disallowance, if subsection E, a notice of a motion to disallow a legislative instrument or provision of an instrument is given to the House of Parliament within 15 days, and within, this is subsection E, within 15 days, the House passes a resolution disallowing the instrument, then the instrument or provision so disallowed ceases to have effect. So have a look at that, read some material about disallowance, and it'll give you a better idea of the process. And just one other thing, consistent meaning. Now this is a separate thought, but I thought I'd put it on the slide for you because to my mind, this is important. So when you're drafting your material, be aware that I'll be looking for a consistency in the methodology and the wording. This is important. Where a different word is used in place where the same word could have been used, I'm entitled to assume that you meant a different meaning, otherwise you would have used the same word. And I think I stressed this last week as well. So think about that when you're drafting a document, and think about that when you are attacking the drafting of a document. So in assessing your work, I'm not the enemy by any means, but I will be looking at the work critically, and I'll be looking to ensure that you maintain consistency in language and format. Now, are there any questions about what we've dealt with so far? And I know it's a quick introduction, but mostly it's an encouragement to look broadly at the material that is available to you. All good? All right. So let's move on and deal with the substance of the material for this week, which deals with common law canons. So the reading is chapters 2 and 4 of your text. And at the end of this week, you should have some cemented ideas in relation to many of the concepts that you considered in statutory interpretation, laws 11059. As I mentioned in week 1, I'd like you to develop your own system of determining and distinguishing between some of the things that you hear quite often in the context of statutory interpretation. So, for example, I'd like you to be able to clearly distinguish between what we mean by a textual approach to statutory interpretation and a purposive approach to statutory interpretation. Tonight, we'll be talking about some of the old rules that we were familiar with in the introductory courses. The Golden Rule, the Mischief Rule, outline the current position in Australia, identify some of the principles and presumptions of statutory interpretation applied by the court, and the use of Latin and other terms, and some of the canons that continue on. Now, the reason that this is particularly relevant for your assessment work is that when you complete your work, I will consider it within the context of the law as it stands, and that includes principles of statutory interpretation. So I want you to be aware that I'll be looking at your work not in isolation, but in context of all of the statutory interpretation principles that are available to you. So that means considering the common law canons and how they might affect the work that you do. Just a word of the prescribed reading and clarification of the page numbers. So in the text, in the reading guide, it says Pearson Geddes, chapter 4, pages 134 through 150. It should read, I think, 169 through to 187. And in chapter 2, instead of 27 to 32, I think it should read 35 to 40. So my apologies for that. So make those allowances. By all means, read more widely than that, but that is the, if you like, the prescribed reading. The other thing is, and I know that Greg has been onto this, and I think a few others, the Bill's Digest is very important, and have a look at the Parliamentary Library in Canberra, which is online, and it provides a great deal of material. So I mentioned earlier the resources that are available to parliamentarians. The Bill's Digest provides information, information packages about proposed laws which explain the legislation, explain the issues behind the legislation, why the legislation was being developed, any controversies or that emerge in relation to the legislation. And all of this is relevant to your assessment work because that is the sort of process that you need to consider within the context of the work that you're doing. So in UCRU, just looking at it, Greg, you identified some work in relation to the Defence Trade Controls Bill and provided a link to the explanatory memorandum. So I'm just going to I've just followed the link as we speak. I'll share the screen now, and this gives you an idea of the sort of content that I think you need to consider to properly undertake the work that you are doing. So you'll see there the Parliamentary Library, which is part of the Parliament of Australia, Bills Digest, in this case, number 91, Defence Trade Controls Bill. I think that was the one, Greg, that you identified. And you'll see information that goes to the background, the purpose, dealing with international treaties, committee consideration, financial implications. You don't need to worry about that. But it provides information about policy positions, key provisions, and then it explains the legislation in a manner which is somewhat consistent with the way in which you need to do your assessment work. So it provides some information about the purpose, the background, all properly resourced, referenced, paginated, of course, and well written. So that is, I think, an excellent resource. Now, does anyone want to say anything about the Bills Digest material or the way in which it might assist you in your assessment work? I take it you've all found that by now. Any questions, comments, elaboration? All right, that's fine. So let's continue on. I'm very keen, of course, for you to draft your laws clearly. So you must write laws confidently expecting that courts and tribunals will interpret them to mean what you intend them to mean. So I'll be reading your material from the perspective as if I was a court or a tribunal and trying to ascertain your true meaning. So why then tonight and this week do we need to consider the common law approaches? What's the relevance? Well, in drafting laws, lawmakers do so within the context of knowing how judges will interpret the legislation. And to interpret the legislation, we need to consider guidance from primarily the High Court. Once again, go back to Project Blue Sky against ABA, 1998, and there's a quote at page 384. I will just highlight this quote now. I'll share it for you on a screen and we'll just have a look at it because I think it's entirely appropriate for the work that you're doing. So it goes to the way in which courts should interpret legislation. I'll share the screen now. To interpret legislation, we consider guidance provided by the High Court. In Project Blue Sky, the plurality said, the duty of the court is to give the words of the statutory provision the meaning that the legislature is taken to have intended them to have. Ordinarily, that meaning, the legal meaning, will correspond with the grammatical meaning, not always, the context of the words, the consequences of a literal or grammatical construction, the purpose of the statute, or the canons of construction may require words of the legislative provision to be read in a way that does not correspond with the literal or grammatical meaning. So, if you like, while you're preparing your assessment work, I'd like you to keep that quote in mind because that's what I'll be keeping in mind when I read your material. And part of that quote includes a reference to the canons of construction. So what are these canons of construction? We know that we must read the words within the context of, amongst other things, these canons. So the first canon of construction is the golden rule. So at the risk of going back over very basic information, I think we all know what the golden rule is. But bear in mind this, that before a bill reaches Parliament, many experienced people will carefully consider the content. So we know that will happen. So in the same way that you're drafting material hypothetically, for real, many people would cast their eyes over your work. And through the parliamentary process, the politicians will carefully consider the bill and the precise wording that you have used, and they'll do that through readings and debate. Now, it becomes the law. However, it may not be perfect. One way of looking at the golden rule is to think of it as a judicial means of correcting a mistake in the wording of an act. The court, in exercising or adopting or using the golden rule, is not attempting to usurp the role of Parliament, certainly not there to change the basis of the law, but rather protect the integrity of Parliament and give effect to what Parliament sought to do by enacting the legislation. So I like to think of the golden rule, not that I teach this in the first statutory interpretation subject, but at this level, I think I can say that you might look at the golden rule as having relevance now as a way in which the courts will identify mistakes and try to resolve that mistake. So let's have a look at an example. It's one that we used in 11059, Adler against George. Can anyone remember what Adler and George is? 1964 2QB7. No? All right, so in that case, the law said it was an offence to obstruct an officer in the vicinity of a place. By applying the golden rule, the court treated the act as if it read in or in the vicinity of the place. I'm sure that that's what Parliament meant, but it's just that people didn't pick up on the exact wording, so the court read it as if there were a couple of extra words in there. So the golden rule in that instance was used by the court when interpreting the statute to avoid a literal meaning, to avoid an absurd result. And it did so by reading in some words into the material. However, by applying the golden rule, it doesn't help where a literal meaning of the words might lead to a result which, while not absurd, is clearly not the outcome that was intended by Parliament. Which means then that we consider the purposive approach. And I think this is overwhelmingly the way in which we should look at legislation now, but I'm not discounting the golden rule. So the purposive approach, we know what that means, don't we? Does anyone want to tell me what the purposive approach is, where it derived, what it means? Any statutory or case law authority for the purposive approach? So what Mills and Meeking? Yes, I think that's always a great case. Thank you, Greg. Anything else? Any other advances on that? Now, I think that you can look at the purposive approach in this manner. I've given you a way of looking at the golden rule that I think is still relevant. Is the statute clear in the meaning? Yep. I think the purposive approach goes back to the old mischief rule. Now, the mischief rule was set out in Hayden's case way back in 1584, and I can guarantee that is the oldest authority that I referred to in any of the law that I consider. So in Hayden's case, the court came up with the mischief rule. They said, look, there are four things here. What was the common law before the making of the act? What was the mischief and the defect for which the common law did not provide? What remedy did Parliament resolve to cure the disease? I love that wording. And number four, the role of the judges is to construct the legislation to suppress the mischief and advance the remedy. So in the golden rule, in the mischief rule, the courts were working on an assumption. They worked on an assumption that Parliament wouldn't have raised a pen or made a law unless something was wrong, unless there was some mischief out there that needed to be fixed, and that the common law hadn't already fixed it. Now, bear in mind, in 1584, the legal landscape was very different. Now we are predominantly, our laws are predominantly based on statute and subordinate legislation. Common law, case law is still there, it's still very important, but it sits behind them and it's less significant. It was almost the reverse in 1584. Statutory law still overrode the common law, but the common law was by far the bulk of the law. Statutes were quite relatively rare, and they would come in at a time when something had to be fixed. So that's why courts in those days would say, all right, well, obviously there's something that they want fixed, so let's find out what that mischief is and see what Parliament decided should be the cure for the disease, and we will try to suppress this mischief and advance the remedy to cure the disease. So that's the common law approach. Mills and Meeking, 1990, certainly advances that. So I think that is the case to consider in this context. And does anyone remember what Mills and Meeking was about? It was about a drink driver, wasn't it? About an acquittal of a drink driver. Anyway, at some stage, have a look at the facts of Mills and Meeking. So, but bear in mind that statute law still overrides the common law. And most of our law is statute law, delegated legislation. And back then, you know, there was no concept of codification, for example, in the criminal code. All of that is a recent phenomenon. But bear in mind that English language is inherently imprecise. And here's part of the problem. Here's part of the difficulty and why we need to consider the purpose of Parliament. Because the same words can be used to express different meanings, or we might use different words to express the same meanings. So I think the samples in your text are, in terms of the same words with different meanings, a simple question, are you mad? Might mean one of two things. Are you angry? Or it might mean, are you insane? So we need to look at the purpose, and that means looking at the context. So when we're dealing with modern statutory interpretation, we must consider the context in order to give proper meaning to those words. So when we talk about the contextual approach now, what's a case that comes to mind, if you like, that adopts the modern approach to context? You can always say Project Blue Sky. That's always a good answer to everything, but it is a different case. It's the one that, for those of you that studied 11059 with me, was the first assessment piece. CIC Insurance against Bankstown Football Club. I'm sure you're all familiar with that case. You've come across it. I like to think of that in terms of advancing the need for considering the contextual approach to statutory interpretation. Now, it's because of that, because of these reasons of considering the context, that I always encourage you to read the Act broadly rather than going straight to a section of the Act. And you must interpret words, phrases, and sections within the setting of the legislation. And when drafting legislation for your assessment, you must consider these aspects. So you must consider the wider issues. All right, I know I've been doing a lot of talking. You're doing well, you're hanging in there. Are there any questions, comments? Are we all good? Okay, I'll keep going. Correcting errors and reading in words in legislation. So we already had one example tonight of where the court read words into legislation to make sense of it. And courts will consider doing that in one of two words, in one of two ways. The first is that they might correct errors or read in words in order to fix things. So if we're looking at, if you like, the golden rule and the idea of fixing mistakes, one mistake might simply be an error in printing. You know, of may mistakenly be typed as or. So it's a printing error. or it might be an error in the grammatical drafting of a document. So that's one type of error. The second is where they need to imply words into the legislation because, through error they were left out. So that was, say, Adler's case, where they put in those extra words, in or. So they're different things, but they're both, if you like, drafting errors. So the courts remedy the first by the golden rule, and as for the second, courts need to take great care if they're going to add in something into words. So you need to consider, for example, if something has to be done, whether courts would add in some words such as within a reasonable time in circumstances where no time is stated. So if in your material you provide an obligation or an opportunity for someone to do something, then, and if there's no times stated, I will imply into that the words to the effect within a reasonable time. Okay, so I guess what I'm saying is this: for the assessment, I will guarantee that I will read your material very carefully. I'll be quick to identify what I think are errors in printing or grammatical drafting. I will also ask myself whether I need to read in words into your draft legislation to give effect to all of the words or make better sense of them. Now, obviously, you would prefer in both instances that I am unable to improve your work. You don't really want me to be applying the golden rule as I read your material. Next week, and for the few weeks after that, we'll provide some practical hints on what is really my favourite part of the areas that we're dealing with in this unit. But just for the moment, be aware that I will read very carefully, more carefully than probably any other assessment work that I do. Now, that said, I will follow the rules. So in the context of implying words into legislation, I note the comments of Lord Mersey in Thompson against Gould, 1910 AC 409, and then some commentary in relation to Birmingham against corrective services. What I'm going to do is just provide some material on a slide so we can follow it together. Now, I do hope that there are no errors in what I've typed. But let's see how we go. All right, so I've said there that I will follow the rules. In the context of applying words in legislation, I note the comments of Lord Mersey. And His Honour said, "It is a strong thing to read into an Act of Parliament words which are not there, and the absence of clear necessity, in the absence of clear necessity, it is the wrong thing to do. Although in Birmingham against Corrective Services Commissioner of New South Wales, McHugh did say it is appropriate to take into account the contemporary emphasis of legislative purpose. Paraphrasing Lord Diplock in Wentworth Securities against Jones, His Honour said, His Honour spoke of three conditions, and that is, first, the court needs to know the mischief. Second, the court must be satisfied that through inadvertence Parliament overlooked an eventuality. And third, the court must state with certainty what words Parliament would have used." And I'm sure that you saw me making some errors, correcting some errors on the run. So that's the sort of approach that I'll adopt when I'm looking at your material. And just to follow on from that discussion, the test that I've been discussing there in those two cases was clarified in a case of R against Young, which was NSW CCA. Spiegelman CG said, in relation to the question of reading in words, that the three conditions set out by Lord Diplock, paraphrased by Justice McHugh, should not be misunderstood. His Lordship did not say that wherever the three conditions are satisfied, a court is at liberty to supply the omission. His Lordship did say that in the absence of any one of the three conditions, the court cannot construe a statute with effect that certain words appear in that statute. So that's the approach that's adopted now in Australia. And I know I'm moving fast, and you may need to reconsider what I'm saying at a later hearing, but thank you for your patience. Again, if you have any questions, comments, please let us know. Okay, the next heading is adding superfluous words, and really what I'm doing is, I guess, identifying the main parts of both the study guide and the text in what I'm doing tonight. Now, in 1906, the High Court heard the case of Pryor against Sherwood. In that case, Sherwood had been conducting an unauthorised betting operation from a laneway in the heart of Sydney, and the relevant legislation said no betting in a house, a room, an office or a place. Now you can see the problem. The statute used three specific examples: house, room and office. They connote a very clear idea of the sort of place that we're thinking about, and then followed up with the more general term place. So when you're thinking of a house or a room and an office, and then say, or any other place, you're thinking along those lines. You're certainly not thinking about a laneway, are you? So this is an example of where the Eugestem generis rule applied to mean that any place had to have a characteristic the same as house, room or office, and that a laneway was sufficiently different from those to satisfy it that no offence had been committed by undertaking the betting in a laneway. Does that make sense? So again, when you're preparing your work, just bear in mind that if you choose to use specific words or specific examples, then I will apply that type of common law canon if you then follow with a more general term. So you need to be very careful. And whilst it can be of great advantage to draft material by using specific examples or words, it may also prove difficult for you in terms of trying to be more general than what you've said in your examples. Now, context and surrounding words. So the question is it better to keep it broad then? Well, see, that creates another problem, doesn't it? Because if you keep everything broad, then you run the risk that it becomes so general that it becomes unworkable, or it introduces absurdity through the very broad nature of what you're trying to say. So it's a balancing act, and there's no right or wrong answer. So I'm sorry that I'm not giving you something better in terms of advice, but it is tricky. Yes, it is tricky. So over the next few weeks, we'll talk about some of the techniques that you might use to proofread, if you like, the work that you do. Okay, so the next heading is context and surrounding words. I think the good example in this case is the Mann-Morris decision. That was the case where Mr. Morris was charged with using the Postal Service in contravention of section 471 subsection 12 of the code, the Commonwealth Code, and it related to sending of letters to wives and relatives of military personnel killed while serving in Afghanistan. It was quite critical of Australia's military involvement, and it actually denigrated the deceased soldiers. Now, that section made it a crime for a person to use a postal service in a way that a reasonable person would regard as, in all the circumstances, menacing, harassing or offensive. And Mr. Morris was charged with 12 counts of using the postal service in an offensive way, and 1 count of using it in a harassing way, and then 8 counts of aiding and abetting. So the court, at first in the criminal court in New South Wales, the Court of Appeal, held that it was valid and that there was an offence committed in those circumstances. But the Crown responded but there was an appeal, and to that appeal, the Crown responded. And it looked at some of the physical aspects associated with the task, or the physical elements, if you like, contained within that section. And it then had regard to the way in which the use was required to be regarded by a reasonable person, and said that it would be wrong to discern the meaning of the word offensive in isolation from the larger statutory expression of other words used to describe the circumstances contained in the physical elements of that subsection. Now, having regard to the interpretive approach mandated by Section 15AA of the Acts Interpretation Act, there was a requirement for the interpretation that best achieved the purpose or object of the Act to be preferred than any other interpretation. So just in that case, and always come back to Section 15AA, so that talks about the purposive approach as the primary approach when considering legislation. All right, I know I'm moving quickly. Yes, was Al Capone caught on using the postal service charge, or was it taxation? Or maybe both, I'm not sure. Now, I've already talked about the Eugestem generis rule, specific matters constraining general matters. There's just one thing, I thought it was tax, yeah. In the notes, there's a mention about legal representation and a presumption that in proceedings, a canon that a person would be normally entitled to be representative. In the notes, which were not written by me, it said that legal representation is not permitted in the Queensland Civil and Administrative Tribunal. I think it actually said Queensland Consumer and Administrative Tribunal, but it is actually Queensland Civil and Administrative Tribunal. And I can say that we have solicitors and barristers appear before us in the tribunal regularly. So if you're thinking of an area of practice that is sometimes overlooked, appearing as an advocate in QCAT, I think, is a great way to generate work. Anyway, that's just something I wanted to clarify when I noticed it in the notes. So let's get back to some of the substance of the work that we're dealing with tonight. And I won't keep you too much longer, so you're doing really well. But let's talk about a couple of case examples now in the context of general words and limiting. So this is the Eugestem generis rule. Now, the example in your text, and have a look at 4.25, specifies that animals may be carried on a ferry, and the drafter may refer to horses, cows, sheep, and other animals. And in that circumstance, it would be an improper reading to suggest that a tiger fell within the words of other animals. So I think that's fairly clear. Let's have a look at these case examples. The first one is this. Section 16 of the Local Government Act, UK, requires a member of a local authority to enter an interest, direct or indirect, into a role, any interest in any contract or proposed contract or other matter to disclose such interest and refrain from voting at a meeting at which the matter was being considered. So the question is, does that cover all matters where the member may have a financial interest? And in Rands against Oldroyd, 1959, the court said that it did. So even though specific words had been used and there was a reference to having an interest in a contract or a proposed contract or other matter, the court looked at the purpose and said it goes much broader than that. Let's look at a second example. And the legislation provided in this second example that no person shall, by speaking, shouting, singing, or playing upon, operating or sounding any musical noise instrument, for doing anything whatsoever to attract together a number of persons in any street, or so as to obstruct traffic, commits an offence. That's what the legislation said. Now, a person in a gorilla skin attracted a crowd but remained mute because of the difficulty of holding a conversation through a gorilla skin. And the question is, upon being charged for committing an offence and gathering or attracting a number of people in the street and obstructing traffic, the court said no, because all of the words that were used in a specific sense related to the making of some noise as the basis upon which the crowd was gathered, which then hence obstructed the traffic. Now, it's really difficult to reconcile those sorts of cases. And in a way, it is a little arbitrary. In the first instance, where we had general words following the specific words, the court said effectively, look, don't worry about the specific words. We're going to take a broader approach here, and we'll look at what it is that Parliament decided was trying to achieve. In the second case, the court said no, because the specific words had a particular context, we're not going to go beyond that. A bit arbitrary. So what's the lesson for your assessment work? When you're preparing your work, I think the lesson is be precise. Where you can, use short sentences. Use only the words that you need. And coming back to a point that we talked about before and Siobhan's question, adding words may well create difficulty. So for your assessment, I will note your ability to convey your message in a simple manner. Now remember, of course, that as lawyers, we're not creating a novel. We're not, I mean, it sounds a bit cruel, but we're not creating something with the intention of entertaining, are we? We're creating something with the intention of conveying as precise a meaning as we can and ensuring that as far as possible, people will understand that meaning clearly. And not just highly educated people, we're writing for everyone. So it's got to be simple, and you've got to, therefore that's why part of the reason I say use short sentences. All right, so we've talked about common law canons tonight. Remember, of course, that there are statutory presumptions. So like all common law rules, Parliament can override these interpretation presumptions through legislation. That means that these presumptions are rebuttable by Parliament and indeed by the court. But there are some things that are very powerful legal concepts, and such as the rule of law, the sanctity of private property, the concept of freedom of the individual. So these concepts are not surrendered lightly. And you must therefore, if you intend in your work to rebut some of these powerful legal concepts, firstly, you need to know what they are. And secondly, you need to rebut any statutory presumption by clear words or by a clear implication such that otherwise the provision would be meaningless. So bear that in mind when you're creating your work. Now let's have a look at an example. A good one, I think, is Coco against the Crown. That was a 1994 High Court decision. And in that case, the plurality said, the presumption is rebuttable and will be displaced if there is a clear implication that authority to enter or remain upon private property was intended. So in that case, it was all about, if you like, the sanctity of private property. Some other, and I'll be brief, some other principles and presumptions: extraterritorial effect. Legislation does not usually have extraterritorial effect. The presumption is included in the Commonwealth Acts Interpretation Act at section 21(1)(b). Legislation can have extraterritorial effect if rebutted by clear words. See section 10. Quick word about remedial or beneficial provisions. A remedial or beneficial provision is broadly construed. That is, courts will construe those statutes to give the greatest benefit to the individual, So in your assessment, if I perceive that the mischief you're trying to remedy is to provide a beneficial provision, I will construe your work as having wide range effect. If your assessment work and your draft legislation deals with revenue issues, bear in mind the general presumption that a person should be required to pay tax only where the provision creating the obligation is clear. So in viewing your material, I will consider the context, I'll consider the purpose, but if there is an ambiguity, I will prefer an interpretation that is in favour of the taxpayer. So if you're creating something that's revenue in nature, just bear that presumption in mind. All right. I think I've just about run out of time, and it's hard work listening to someone for as long as we have, but you've done well. Next week, I'm going to start with some discussions about the Australian Law Reform Commission. I know there's been some good work on UCRU. If you're not following UCRU, please do so. If you haven't contributed through UCRU, please consider doing so, bearing in mind the third assessment in this course, this unit. So during the week, have a look at the Australian Law Reform Commission. It's a valuable resource. It provides information about common law statutory interpretation principles. If you go to the site, you can see that you can subscribe through e-news to get email material, and have a look at the inquiries commentary, because it provides a wide range of law reform. For example, law reform to do with elder abuse, class actions, lawyers' litigation fundings, calls for Indigenous justice bodies. And in the context of family law, there is a current call for submissions in terms of the wide-ranging effect of family law disputes, protection of the best interest of children and their safety. So have a look at the Australian Law Reform Commission. You'll find a number of excellent publications and links to law reform resources, and we'll pick up on that point next week. Okay, so thanks for your patience. Are there any questions, comments before we go? Otherwise, I'll wrap it up for this evening. All good? Okay, well done. We'll see you next week, and please do some homework. Keep up the homework. I'm sure you're all doing well in the meantime. See you then.